Now, this morning, we are truly privileged to have two distinguished speakers to share their expertise, experience, and perspectives on this topic. They are the Honorable Chief Justice J.C. Mark Richard, Chief Justice of New Brunswick, Canada, and Judge Professor Fabricio Bittencourt de Cruz. Now, a quick intro for our two distinguished gentlemen before I invite them on stage, and of course, be reminded that the bio is also available on the app. Now, let's start with Chief Justice C.J. Mark Richard. Now, he serves on the Canadian Judicial Council as a member of the Council's Executive Conduct, Salaries and Benefits, and Renewal Committees. As a lawyer, Chief Justice Richard served on several national and provincial committees, task forces, or advisory groups of the Canadian Bar Association, as well as the New Brunswick Law Society. He was elected president of both organizations. Now, in 2002, he was appointed Queen's Counsel, and a year later, a judge of the Court of Appeal of New Brunswick. He was appointed as the Chief Justice in May 2018 and has served on countless judicial committees, including the Canadian Judicial Ethics Advisory Committee and the Judges Association's Conduct Review Committee, eventually becoming the chair of both. He became a member of the Board of Directors of the Canadian Superior Courts Judges Association in 2004, and in 2015, he was elected the association's president, becoming the first judge from New Brunswick to hold that office. Now, just a bit more. CJ, do bear with me. And I'm sure you know all this. Chief Justice Richard frequently lectures for the Canadian Bar Association and the National Judicial Institute, of which he is a member of the Board of Directors and chairs the Finance Committee, the Advocate Society, the Canadian Institute for the Administration of Justice, of which he served 6 years as a member of the Board of Directors, and the Federation of Law Society's National Criminal Law Program. And moving on to our next speaker, we have Judge Professor Fabricio Bittencourt de Cruz. Now, he is the former Secretary General of the Brazilian National Council of Justice. He is a federal judge and also works as an international law PhD professor at State University of Ponta Grossa School of Law, where he teaches master's and doctoral students in legal design and access to justice optimization. Now, Judge Prof. Fabricio is the leader of the Mind the Gap Innovation in Law project, whose core purpose is the application and creation of information technology solutions to legal processes and procedures. In particular, the applicability of artificial intelligence techniques to legal knowledge. With that said, ladies and gentlemen, the stage is set for our two distinguished speakers. Let's put our hands together for CJ Mark Richard and Judge Professor Fabricio Bittencourt. Thank you.
Good morning, everyone. It's great to see everyone on this second day of this wonderful conference. And I'd like to begin by extending sincere gratitude, words of gratitude, thanks to our hosts for having organized such a great conference, and of course, all of the good people at the IACA who make this happen year after year. I've been a member of IACA for 6 years, but this is my first conference, and boy, am I impressed. This won't be my last one. I would also like to particularly thank the speakers for yesterday. It was a wonderful conference. All of the sessions I attended were of great quality. It's a privilege for me to join Professor or Judge Fabricio and engage in dialogue that speaks really to the heart of our work as stewards of justice. We all heard yesterday the Chief Justice of Singapore emphasized that the role of the modern judge is more than just adjudicative. We're also responsible for system change, and I agree with that. I could not agree more. I'm here today to talk to you a little bit about our experience in New Brunswick, a small province in a big country with big aspirations for judicial reform. Our path has been one of collaboration, resilience, and commitment to modernization, even in the face of very limited resources, and I'll emphasize that. For those of you who come from wealthy countries where the countries are investing piles of money in the justice system. I suspect that's many of you. Well, maybe you can tune out or go back to sleep. I want to talk to those of you who are having resource problems. And I want to talk to you about how we in our province have been trying to overcome those resource difficulties by leveraging community organizations and thinking outside the box. That's what I'm talking to you about today. It's a story about big dreams despite limited resources, and it is very much a work in progress. This is what we are doing now. This is not what we have done to accomplish anything. Yesterday, there was one of the speakers at the plenary in the afternoon from Comcast, I think, and he had a graph, and he said paper, AI at the other end, and some in between, hybrid and so on. We're still paper. We want to move away from paper. We're going to move away from paper, despite the provincial government not coming to the table and doing what it ought to do, which is invest proper monies. So what I'm trying to focus on today is I'm going to tell you a little bit about New Brunswick, about our context, and then I'll share some of our recent initiatives aimed at enhancing access to justice. And finally, I'll conclude with some reflections on the key takeaways from our work in the hope that they may inspire some of you to think outside that box that we've been thinking in and working in for years. So a little bit about the New Brunswick context, but first, a few words about Canada. So Canada is a democratic federation with a parliamentary system. Power is divided between the federal government and the 10 provinces and 3 territories. So constitutionally, there are certain powers that are federal, like criminal law, for example, foreign policy, defense, immigration, and so on. And then there are some powers that are provincial. And that includes the administration of justice. It also includes health and education, which are the big portfolios for any government. Well, because it includes the administration of justice, there's not equality in our country. Some provinces have a lot more resources than others. They have bigger populations, better tax revenue. They also have better natural resources. The province of Alberta, for example, has oil and gas. And as a result, the funds invested for the administration of justice are not equal across the various provinces, and that makes a difference. That's the drawback of our constitutional structure. Now, a few words about the province of New Brunswick. As you can see from the arrow, we are that small province highlighted in red. We have a population of only about 760,000 people, and we operate in a bilingual framework. Now, think about that for a second. A population of less than 1 million, and we are Canada's only officially bilingual province. Only officially bilingual province. Canada itself is a bilingual country. French and English are the languages of Canada. They are also the languages of New Brunswick. And constitutionally, that is protected. And equality is protected for both linguistic communities. And that means that we cannot do anything unless we do it in both languages. And of course, the expenses that are related to that have to be absorbed by the provincial government. There are some federal subsidies for that, but it's not great. And that's not a drawback. I mean, that exemplifies our culture and of having 2 founding nations, in addition to our First Nations, of course, which is another topic. But their languages are not protected. The French and English are the official languages. We certainly do not rank among Canada's wealthiest provinces. In fact, the opposite. Our main resources are forestry, agriculture, and fisheries. With that context in mind, and particularly the financial limitations, when I became Chief Justice, I noted that my predecessor had focused on other areas that were really necessary for the improvement of justice in our province, but access to justice was not one of them on which he had time to focus. I decided to make that the focus of my tenure as Chief Justice. I've been there for 6 years. Unfortunately, had to navigate through the COVID periods, so that didn't help. One of the first things that I did is approach the Minister of Justice of the province and recommended or put forth the idea of creating an Access to Justice Committee with multiple stakeholders. Initially, that wasn't well received, but thanks to a good deputy minister, we managed to put that together. And then COVID happened. And of course, the meetings couldn't take place, and other priorities came to the forefront. We ended up having to do lots on video conferencing and enhance our technology for that. So the access to justice, unfortunately, took a back burner. However, that being said, once we were able to overcome the COVID period and get back on our feet, we were able to identify a group of good stakeholders that might play a vital role in access to justice. And we operate, as the slide shows, on an executive model, which is the worst of models for court administration. That's another thing that I'm working on, but never mind that for the time being. It's important for us to have the justice people at the table, but they were not taking the lead, which really they should have been. So this is what we did. With some money from the New Brunswick Law Foundation, we identified a group of community stakeholders who would be important in addition to government. Particularly, we have we have more than 2 universities. We have 4 universities in New Brunswick, but we have 2 that offer that have law faculties. One in English, one in French. So we identified the universities as key community players in an effort to enhance access to justice and bring in some initiatives. And also some other civil society organizations. In particular, out of that list is the Law Foundation of New Brunswick, which was instrumental in funding one of our first initiatives. So what we did is we held a summit, and it was organized by the Canadian Institute for the Administration of Justice, which is a Canadian organization, but that organizes conferences such as that one, and University of New Brunswick's Legal Innovation Lab. Now, the Innovation Lab is dedicated to the study of law, technology, and access to justice. It's a new creation at the University of New Brunswick, and it's funded by the Canada's Research Chair, Dr. Aguirre Penesi, who would have loved to have been here to co-present with me, but unfortunately had teaching obligations in Fredericton this week. And it's also funded by the Law Foundation and the Canadian Bar Association Law for the Future Fund. So we identified the Innovation Lab as being, since that was a startup as well, to be part of the startup with us. And what the Innovation Lab seeks to do is to work in policy-making methods of e-justice designed to enhance access to justice in our province. So it was a perfect partner for us to look to. And with the CIAJ, the Canadian Institute for the Administration of Justice, we held this 2 or 3 day summit at the university at the end of August last year. And we focused primarily on family justice reform and on digitization and the modernization of the courts. And there's a report. It's available at on the CIAJ website, and it called for 7 changes. Change in design, change driven by the community, change in funding priorities, change in the family justice system, because that's what we had particularly focused on. I mean, we've got long waiting times to adjudicate family matters, and that's unacceptable in a society like ours and in these modern times. It also called for a change as a result of a rural population. Our province is not very big on that map you saw, but however, it's a 5-hour drive from one end of the province to the other. And so it's sparsely populated in the north, particularly now where the people are moving from rural centers back to the urban centers, leaving even less population in the rural areas. And of course, we need to change that fit in an officially bilingual province. So those were the areas identified by this summit. The summit was attended by various groups, including community leaders who were representative of various community groups and disadvantaged groups. The offshoot of the summit was a revived advisory committee on access to justice, which I sort of chair, but I'm more an honorary chair. One of my colleagues on the Court of Appeal is actually chairing it. And that committee brings together the stakeholders to communally develop ideas regarding access to justice. We have a government representatives from both universities, and others. Now, the committee has identified really 4 areas where we would create subcommittees and give them particular tasks with terms of reference. One of them is going to focus on a Court of Appeal pro bono program. We have a situation in our province where, unfortunately, a lot of people are self-represented in a court of appeal. This is a new, well, it's not that new. I've been a judge for 21 years, but it's a phenomenon that I would say in the last 10 years has been exacerbated significantly. What happens is people go and they hire lawyers, particularly in family matters, and they litigate. And I'm a believer in a new system for family that is not so adversarial, but they litigate under the adversarial process, and they spend all the money, and then they want to appeal, or the loser wants to appeal, and they come to the Court of Appeal with no counsel because the lawyers have already expended all the money. I mean, I'm not necessarily putting fault on lawyers. They have to get paid, but that's just a reality of things. And there's a lot of lawyers in our province who would love to have experience as appellate advocacy experience, but they have no opportunities because, again, you know, finances being what it is, it used to be back when I was started in 1983-84, the senior lawyer would bring the junior lawyer with him. Now the senior lawyer gets the junior lawyer to do all the work and leaves the junior lawyer at home and goes up and takes the credit when they argue the case in the Court of Appeal. That's the reality in our province. So a lot of young lawyers are really chomping at the bit to get appellate experience, and they're not getting it. So what better than to give them the opportunity? Now, of course, because it's pro bono, it costs money. Well, here's the other thing. What about leveraging law students? Law students are looking forward to working with lawyers. So if we are able to pair a law student with a lawyer who's willing to do pro bono and match them to an appropriate case to be argued in the Court of Appeal, it's a win-win-win situation. So that's what that subcommittee is currently working on. We've also identified that rules review is necessary. Our rules of court were adopted in 1982. They've been changed periodically over the years, but there's never been a huge overhaul. And we are definitely no longer living in the times of 1982 for the very reasons that I gave, more people representing themselves, etc. So we need to change the rules and make them more understandable, more simple. So that committee, as well as we created a subcommittee to look into that, to work with the Law Society, and the lawyers the Law Society is one of our partners in this organization. So everybody's on board to do this. Because the provincial government's not doing it, it's not funding, we're going to take the bull by the horns and we're going to get it done. And finally, a committee for assembly, referral, and communications. This is to help us map and understand the needs of New Brunswick communities and to determine how to better advance. As a side to that, or in addition to that, now we're looking at modernizing the court's IT structure. Again, the provincial government's not doing it. Now, we've just had an election. I haven't spoken to the new minister yet. In fact, I just sent him a letter congratulating him yesterday. And I'm hoping that he'll have a better outlook on this and he'll be willing to put in some funds. But in any event, we're going to shame them into it, because with the Innovation Lab, we're actually going to put a process together. We're going to leverage IT, and we're going to identify what is suited for the needs of New Brunswick. Now, I can't say that we're going to be able to implement it. That's going to take money. That's going to take manpower or people power. And the government of New Brunswick is going to have to come to the table, but at least they'll know what they're coming to the table for, and they won't need to hire consultants. We will have done all that work for them. So that's the other side of it. One of the initiatives that we're able to do without much difficulty and without government is that we're going to partner with the university's lab to develop an e-filing system for uncontested divorce. And that'll be done through the pro bono programs that the university students are already involved in. So those are some of the things. Our court website, if you go and look at our court website, I don't think I put anywhere the URL because it's embarrassing. It's old. And in order to get it changed, we've got to go to the province. We did that many years ago. Province it was just tweaking, and I said that's no good. I don't want to tweak. I want their website redone. So we're doing that with the Innovation Lab again. And we're going to do it. We'll present a package to the government of New Brunswick. It'll already be done. And the goals of the website, of course, should be, at least in my view, would be to educate the public, facilitate access, to communicate with stakeholders, and to connect litigants to resources. So we're working on that. So in the future, we're also preparing a data strategy for the court system and to modernize it along with technology. This is where I wish Professor Panesi was here to listen to all of the presentations on AI, because she speaks that language a lot better than I do. So anyway, some of the takeaways from this. What's the purpose of my telling you what we're doing in our little province? Well, the takeaways that I hope some of you will grasp is that collaboration and open communication channels between stakeholders and court leaderships are able to find solution-focused initiatives. And that if we collaborate, we build a momentum, and we get the momentum. We get the provincial employees involved on the ground so that they are part of this. And when it comes time to actually make a pitch for funding, they know what we're talking about. They've been party to developing the solution. There are ethical issues involved with this, and that's why I don't put all my judges on these committees, because you don't want to, in the event there were lawsuits arising against some of the stakeholders or something that came to the Court of Appeal, I wouldn't be able to sit because I've been working with these people, but I still have a court that's able to do that. It also develops mentorship. It's really good at that. It gives lawyers an opportunity to learn. It gives students an opportunity to learn. It establishes those connections between the two. It enables them to develop programs and feel part of the system, so that when they become lawyers, when they become the leaders of the law societies and of the Canadian Bar Association, when they become the future judges, they will be vested because they will have been a part of creating the system in which they work. So my point is to you, think outside the box. There are probably organizations out there who would love to partner with you and help you develop some of these programs. And take advantage of that. If you are in a jurisdiction where the province is not, or the country is not giving you the monies that you need, the resources that you need, the man or people power rather that you need, take charge, get it done. It's doable. That's my pitch. Thank you.
Good morning, ladies and gentlemen. It's an honor to be here with you. I'm seeing some familiar faces, some friends of mine, Pam, Luis. Congrats for this incredible event. I came here to tell you a story about a simple project with huge impacts in the Brazilian federal judicial system. And I came here not just to tell you this story, but through this story, through this narrative, to deliver you, to share with you a new methodology. A methodology which can change the way you innovate in your judicial systems from bottom up. Today, I'm excited to share an experience of applying legal design and visual law within the Brazilian justice system. This story revolves around a collaborative project developed at the first instance of a federal Brazilian court involving just 4 people, a federal judge, 2 public servants, and an intern. This project's concept originated from my role as a law professor at the State University of Ponta Grossa in Brazil, where I lead the project Mind the Gap, a collaborative, academic, and scientific initiative that bridges law, innovation, and technology. Mind the Gap has 5 areas of research which converge on a central theme: optimizing access to justice. The word optimizing perfectly captures the essence of Mind the Gap. Optimus in Latin means achieving more with less, accomplishing more, better, and faster. We conduct both theoretical and empirical research on topics like artificial intelligence, blockchain, and smart contracts, known as hard skills because mastering them requires long academic and professional dedication. But we also focus on soft skills, providing knowledge in plain language, legal design, and visual law. These skills are easy to replicate with low operational costs, making them ideal for training public servants in the judiciary to develop innovative solutions. From the academic and scientific perspectives of Mind the Gap, we recognize the potential to introduce an innovative mindset in the Brazilian Federal Court, a shift we call embracing soft skills. To make this shift happen, we rely on design thinking as our guiding framework. It bridges the gap between law and design, tradition and innovation, rules and creativity. For this talk, I've highlighted 4 key traits of design thinking. The first is problem-solving orientation, the ability to identify, analyze, and develop solutions for complex challenges. The second is a human-centered approach, which places the user's needs, desires, and context at the core of the design process. The third is empathy, the ability to understand and emotionally connect with users' needs, thoughts, and feelings. The fourth is co-creation, which brings in users, stakeholders, and various participants to the design process. This collaboration enriches and informs the solutions developed through design thinking. I'd also like to introduce 4 key stages in the practical application of design thinking. The first stage is inspiration, the spark that drives innovation and creativity in the design process. The second stage is prototyping, where we create early models or preliminary solutions to test ideas and concepts from the very start. The third stage is iteration, a process of refining designs based on continuous feedback and learning. And the fourth stage is ongoing validation, a constant cycle of testing and improving solutions based on real user feedback. In our academic and scientific work, we've shown that design thinking and legal design are not only technically feasible, but also legally sound in Brazilian law. They help make legal outputs more visually accessible. But we took a step further, proactively addressing the challenges of the Brazilian judiciary through the lens of optimizing access to justice. After all, big challenges create big opportunities for innovation. While the Brazilian justice system shows efficiency in terms of cases judged each year, this hasn't been enough to handle the constant influx of new cases, leading to a growing backlog. One of our Constitution's core principles is wide access to justice, or the broadest possible access to the justice system. With significant social challenges and barriers preventing much of the population from accessing the judiciary, this is a principle we simply cannot compromise. In 2023, new case field reached 37 million, while Brazilian judges resolved 36.6 million cases. The number of new cases exceeded those resolved, leaving us with a backlog, actual backlog of 84.3 million cases. Undeniable, our greatest challenge. To offer a more dynamic perspective, here's some recent statistical data from the Justice in Numbers report by the Brazilian National Justice Council. On this chart, we see the annual number of cases entering the judiciary, with about 27.5 million new cases in 2020, rising to 36.9 million in 2023. The upward trend is clear. The second chart shows the number of cases resolved in Brazilian judiciary from 2020 to 2023. On the right, a scale ranging from 25 to 40 million highlights the increasing efficiency and outcomes achieved by Brazilian judges. Our main challenges are evident in this third chart, which compares new cases with those resolved each year. While judges' efficiency has improved, as shown in the dark and green tones, the number of new cases has consistently exceeded those resolved. This pattern has persisted for the past 20 years, with new cases each year surpassing the judiciary's capacity to keep up. This fourth chart highlights the increasing backlog from 2020 to 2023. The backlog grew from about 82 million cases in 2020 to around 84 million in 2023. This macro scenario clearly underscores the urgent need for both solutions that move beyond the traditionalism anchoring the Brazilian administration of justice. In response to this scenario, we designed, developed, and implemented a project to optimize access to justice through legal design and visual law. This initiative specifically targeted criminal procedures in the first instance unit of the federal justice under my responsibility as a federal judge. The focus was clear: reduce operational costs and deliver greater value to the community. Our project aimed to increase efficiency, streamline workflows, raise judicial service standards, and improve citizen satisfaction with judicial services. It all started with a key realization: communication in criminal cases needed to improve. When someone was convicted, the legal complexities in summons orders and admonitory hearings often made it difficult for citizens to fully understand what was expected of them during the sentence compliance. After 18 months of empirical and scientific study by Mind the Gap team, we discovered that summons orders failed to clearly convey that convicted individuals need to do. People attended admonitory hearings without a full understanding of their responsibilities. And even after these hearings, many were still unsure of how to fulfill their sentences. It's important to note that both the summons order and admonitory hearings are procedural acts in Brazilian law. They serve to communicate the final criminal conviction, explain how the sentence should be served, and warn about the consequence of non-compliance. The project was built around two main objectives. First, to improve communication in summons orders for individuals convicted in criminal cases. Two, to eliminate the need for admonitory hearings. This is the key, to eliminate the need for admonitory hearings. Our initial hypothesis was simple. By integrating legal design, visual law, and plain language into the summons order, we could enhance communication with convicted individuals. This would make the admonitory hearing unnecessary, as the summons itself would effectively communicate, explain, and warn. 3 essential principles guided the project: simplicity, replicability, and adaptability. The process had to be simple, clear, and accessible to everyone involved. Replicability meant that the other units in Brazilian judiciary could easily adopt the guide, and adaptability ensured that the project could evolve and improve with future updates. This vision led to a project with title, Do You Know Who You're Talking To? The name carries a deep meaning. We realized that the language in our summons orders was essentially a message between the judge and the bailiff, not between the judge and the convicted citizen. We needed a way to make this communication more direct, simple, and accessible, creating a clear connection between the judge and the person required to comply with their sentence. This shift changed how we saw the summons order. It was no longer just a document to be delivered, but an optimized communication platform for the convicted system. From this powerful insight, this visual law guide was created. We created this guide to go along with the summons orders, providing clear instructions for the sentence compliance. While the instructions are in Portuguese, the guide stands out for its thoughtful elements designs, like typography, layout, icons, and visual language. Every detail was carefully crafted to make this format unique. On the second page, we included a question and answer section along with a QR code. This QR code provides access to an additional instruction tutorial, offering even more clarity. This approach, combining plain language with visual delivery, is consistent throughout the entire guide. This project is the result of collaboration between 4 people, just 4 people, from 2 generations. That's the key. Blending legal expertise and maturity with youthful creativity to achieve this outcome. Moreover, the project aligns with the Brazilian judiciary's macro challenge for the next 6 years, as outlined by the National Justice Council. By integrating plain language and innovative methodologies, it aims to improve efficiency across judiciary. As a result, the project eliminated the need for admonitory hearings, a procedural act that was often inefficient, time-consuming, and most importantly, costly. The project has external validation and it's being used by several other units within the Brazilian federal justice. It has already been updated to new versions, tailored to fit the specific needs for each unit. This initiative has also achieved significant cost savings in Brazil, in federal justice unit where it was first implemented, reducing expenses by around 900,000 Brazilian reais annually in public and private resources. If adopted by all criminal units within the Brazilian judiciary, it could save close to 1 billion Brazilian reals per year, about $200 million US. Beyond the measurable results, there is an intangible outcome, a cultural shift in the unit where we implemented this project 2 years ago. For me, this cultural change is the project's greatest achievement. A culture of innovation has taken root. Public servants now feel empowered to unleash their creativity, propose solutions, and test new ideas. This is why I'm eager to present this project as a case study, highlighting this cultural shift at its most significant impact. Naturally, we face some challenges. We trained public servants in design thinking from the ground up, Pam. Some hesitated, holding on to traditional mindsets, and a few lawyers questioned where the guide was the best solution. In a recent survey conducted by one of my doctoral students, just about 5% of lawyers indicated a preference for the admonitory hearing model. Because of this, a hybrid approach is recommended, holding admonitory hearings in cases where traditional-minded lawyers see them as the better option. The most important takeaway for all of us here is this. Design thinking, legal design, and visual law are not just effective, they are shareable, they are teachable, they are very transformative. As a professor, I have the privilege of passing these soft skills on to my doctoral students. I teach and apply these methodologies as practical tools that are meant to be shared and expanded upon. In my course, Legal Design and Optimization of Access to Justice, the projects my students create consistently deliver remarkable results. Let me share a message from one of our project participants, our intern, Elena. She wrote, "Just stopping by to say thank you for being part of this incredible project. Interning at the Federal Justice is a dream coming true, and having the opportunity to work with you all has certainly already changed the course of my future." I traveled here from Brazil not just to share this story, but to bring an important message. Design thinking, legal design, and visual law are fully applicable for optimizing access to justice. I came here as a witness to show that these methodologies offer a set of soft skills that are quick to learn, easy to share, and capable of transforming judicial systems around the world. Please feel free to contact me afterwards. Thank you very much for your attention. I really appreciate it.
And with that, we are ready for the Q&A for our plenary session. Once again, just raise your hand, identify yourself to our speakers, and we'll have the mic delivered to you in no time. Thank you. Any questions for the two speakers and gentlemen on stage? Just raise your hand. CJ suggests a coffee break. Would anyone like to get the ball rolling with question number 1 for the day? We have 2, right? Let's start with the First Lady, front row.
Hi, thank you very much for your presentation, both your presentations. My question is for Judge Bittencourt de Cruz about the visual. It's my understanding that more and more people really don't read or get their information from reading, which is odd because all of us are certainly raised with that thought that that's how we're going to get information. So I'm very taken with the idea of more visual instruction, and I'm wondering if your court or anybody's really has gone more towards video and visual, those kinds of explanations, not only for how to navigate the courts, but what the courts are doing and what significant rulings mean to the public. Because I know in my court, in my state, we're looking more towards now video and how it seems like younger people are getting their information that way. So I was wondering if you could comment on that.
Thank you so much. I really appreciate your question. Talking about visual law, it's actually a new culture. And from my academic point of view, not just professional, from inside the court, we are noticing that mainly most of these articles dealing with visual law approach and legal design and design thinking are operational. But there are just a few with quantitative analysis of the real impact and outcomes of visual applications. So from my point of view, it's important to adapt this approach, this culture, for each country's culture. For instance, in Brazil, we are a civil law country. So we really need to rely our communications in texts. For sure, 99% of our processes are e-files, but our internal culture is just to transform your text in a PDF format and deliver it to the system. But thinking about access to justice in deliver a more powerful communication, should be better to use videos, charts, infographics, any kind of communication that you can use the power of the technology, like time lapses, like georeferencing photos, and all kinds of approaches that you can surpass the text, because we have so power in our hands, and we think about, when we begin to think about it, it's very interesting to just use the tools. We use the tools and the text in our hands to deliver a more powerful message.
Can I add, if you are interested in visual, check out the website of the Justice Education Society of British Columbia. They really do a good job with a visual teaching as an access to justice means. It's really good. But I wanted to just congratulate my colleague here. You've given me some great ideas with this new model. It's really good because, I mean, there are documents that we have to give. You have to serve a summons. It's what it is, or you have to issue an order of probation and so on. And to break it down into plain language and a visual like that, those are great ideas. Thank you.
It was a very important coincidence, Mark, in this project, which was two generations together. Because when you talk about soft skills and use of the apps that are in your iPad and mine, from my point of view, I'm a 6 years old man. I even know how to deal with Canva. But Elena, our intern, with 19 years old, she could do it. She could do it. So the beauty of visual law, the beauty of co-creation, the beauty of thinking about the user experiences and contexts is to think on design through the lens of more than one generation. It's a very key and important kind of thinking. More than one generation together delivering something different and more effective for the entire people, the citizenship. Thank you very much, Mark.
And we do have the next question by Alina. Thank you.
Yes, thank you for both presenters. I was curious about the situation in Canada, so my question is for Mark Richard. I know that there are various projects developing digital justice and solution for courts in various places. And I was wondering whether solutions that are developed by different universities are dedicated to specific courts, or are they also sharing or using of these projects in other parts of Canada?
Thank you. If I could be blunt for a minute, I think we missed the boat in Canada when technology started overtaking us. And what we did is we left each province and every jurisdiction to do its own thing. The Canadian Judicial Council, on which I sit as a Chief Justice, all Chief Justices and as Associate Chief Justices sit on that council. One of its goals is to try to harmonize the approaches across the country. And I think we've issued some good guidelines. A lot of these are available on the Canadian Judicial Council website. I'm not sure if they're available to the general public, but if you're interested, I can certainly provide you with some of that documentation that makes recommendations, but it doesn't mandate a universal approach across the country. And I really think we missed the boat. I mean, we had British Columbia develop their own e-filing system from scratch. Saskatchewan and Alberta did something different. Ontario is in the process of spending millions of dollars to have Thomson Reuters do it for them. And then you've got provinces like ours who have nothing for e-filing. We should have looked for a harmonization across the board. And unfortunately, I mean, if you want more information as to, I'm aware of the status in every province because I'm looking with envy and trying to emulate one of them. But even better, I think, with what we're doing with the Innovation Lab, I think we're trying to get ahead of the curve, and instead of just designing a typical e-filing system, integrating it with EI so that you can have the machine talk to the individual, determine the needs, and then spit out the form at the end.
Thank you, Alina, for the question. And on that side, thank you, Mike Runner.
Thank you for the two speakers. It's Emel Arfewi, judge from Tunisia. My question is for Judge Mark Richer from Canada. I was impressed by the program Pro Bono and how to implicate students to a Pro Bono program, etc., with the lawyers. And my question is, do you have statistics of the pro bono program and how this progress the access to justice, especially for most vulnerable people and people who left behind, like, for example, women, minorities, etc. Thank you.
I can't give you statistics because, as I said, this is a work in progress. I can tell you, though, that the idea of a pro bono court of appeal was not something that we came up with out of the air. It's used in, again, British Columbia has a pro bono program. The idea of matching a student with a lawyer, however, is something that will be unique to New Brunswick. I can't give you statistics. We hope to get that off the ground probably in January. There are logistics involved. Of course, you have to realize who's going to hold the office, who's going to have the office for the intakes, and we're going to coordinate with the registry of the Court of Appeal so that we can identify the individuals and then call them and offer services from the pro bono clinic. We also have to coordinate that with legal aid because, of course, we don't want to be taking work away from the legal aid lawyers if it's legitimately for them. But hopefully at some point, and if you want to give me your card, I can't give you mine because I left them in my other jacket, but I would gladly communicate with you as it goes on and provide you additional details. I would gladly do that.
Thank you. And next. Oh, right at the front. Our youngest attendee, I believe.
My question is to Judge Fabricio. Why is the number of the cases that go to the judicial growing in such a large scale in the last years?
This is my son. Good question, son. Yeah. Brazil is a federation with 46 states, 27 constitutions, more than 3,000 municipalities, and in 5 different regions. We are a continent like Canada. And as a federal system, we have so much complexities on our legislation. And all of our main structural laws are made by our Congress, Federal Congress. And we are a very rich country with different delivering money to the people. So we have much poor people needed to achieve the just system. And we decided in our constitution just not to cover the expenses for all the people who who needs to go to the justice system. So our justice system is not costly. It's free of cost for millions of people. So that's the main reason, because if we could always think, keep our thoughts just in human resources, we will never achieve the goal to better deliver these numbers. So that's the main reason, because this kind of approach, like legal design, visual law, optimizing what we're doing day by day, it's a very interesting approach.
Very good question. A future judge in the making. Do we have the second youngest attendee ready to ask any question? We do have time for one or two more, so seize the moment. Okay. Anyone at the back? All right, if not, let's give this gentleman a big hand, shall we? Thank you. Thank you once again to CJ Maruchard and Judge Prof. Fabricio Bittencourt. That was a good start. Thank you for setting the right tone and rhythm to day 2.